So today's panel this morning is going to be on soft law governance of specific AI applications. And it's going to be structured a little bit differently. We're just going to have a conversation. There's not going to be any presentations. I'm going to ask the panel a series of questions, and they're each just going to tell me their answers and have a discussion amongst themselves. And if anybody of you, sorry, can you guys hear me now? Yeah? Okay, sorry about that. So we're just going to have a panel today. It's going to be conversational. Nobody's going to be presenting. I'm going to ask a series of questions. They're going to answer to the best of their ability and have a discussion amongst themselves. And if anybody has any questions, please raise your hand during the panel, and one of them will answer. There's no need to wait till the end. So with further ado, I'm going to introduce the panelists, and then we'll get into the questions. So today we have Dan Merkle, who's chairman and CEO of FaceFirst Incorporated, a biometric identity company supporting private and public organizations to protect people and assets. Dan has been instrumental in developing soft law mechanisms within software applications for the last 2 decades. We have Professor Tracy Pearl, who's professor of law at University of Oklahoma, and she studies and is a scholar on emerging technology and the law, and researches and writes about risk regulation, tort law, Internet of Things, and its application to autonomous vehicles, electronic warrants, and other forms of technology. We have Adam, who's a senior fellow at the R Street Institute, who had a panel or a discussion yesterday. And he has spent the last 12 years as a senior fellow at the Mercatus Center at George Mason University and has authored several books and publications and reports on emerging technology governance. And lastly, we have Lucy, who is at the School of Life Sciences here at ASU and the Institute of Neuroethics. She's a scholar and PhD candidate there and focuses on governance and political economies of neurotechnology. She also researches and writes about legal and soft law tools and other emerging technologies, including AI, genomic editing, and Internet of Things. So before we start, I just want to give a brief overview of what soft law and hard law is. It seems like everybody's here has talked about these concepts but hasn't really defined what they are. So in a broad sense, there's 2 ways to govern anything. There's through hard law or public regulation, or private law, like certifications or standards, or otherwise known as soft law. And the major difference is if you break a hard law, there's some sort of state-backed enforcement. You might go to jail if you're a bad actor or get fined, whereas soft law is a little bit different. You're not going to experience those things. You might get your membership revoked for something. You might lose out on a certification. You might experience market disadvantages and so on. But the main difference is it's state-backed versus non-state-backed enforcement. So we see these things, or these 2 approaches, coming to sort of emerging for AI governance. And this panel is going to talk about the soft law approaches to that and its specific applications in different industries. But to start, we're going to sort of start a little bit broadly and then get into these specific applications and the more specific nuances of soft law and the different types and mechanisms and how they work. So the first question to everybody is there seems to be a lot of AI problems out there. What sort of AI problems frequently come up in your areas of work?
Well, there's quite a few. I recently wrote a paper on AI policy called Mapping 7 Fault Lines in the AI Policy World, and it basically identified a lot of the common concerns we've seen come up in the last 25 years for the internet, social media, and digital sector in general. Everything from privacy, security, safety, both physical and psychic. Job loss concern is something that's perked back up. Concerns about national security, existential risk, which is the broadest category of concern about AI, and then concerns about disinformation, misinformation. I think those are the 7. The ones that are attracting the most interest from policymakers, federal, state, local, and international level.
I think I write a lot about autonomous vehicles, and one of the unique things about that technology is that every iteration of autonomous vehicles introduces a completely new set of problems. So for example, right now we have semi-autonomous vehicles on the road, and the big problem there is controlling the relationship between the semi-autonomous driving system and the human driver, both of which have to be engaged with the car for it to operate safely. And companies like Tesla are really struggling to do that. The car itself is making a set of faulty assumptions about what the driver is doing and how closely the driver is supervising. And the driver often is making a set of faulty assumptions about what the car is doing. When it comes to fully autonomous autonomous vehicles, we heard from Whitney Steele at Waymo yesterday that the big problem is teaching cars about the complexity of the driving environment. She said yesterday that they have an entire team of people just devoted to teaching cars about what bikes look like. And so that's a real challenge, is making cars safe enough to navigate all of the possible challenges that you encounter on the road. From a legal perspective, the big issue is how all of this intersects with the Fourth Amendment and what searches and seizures look like in an era of fully driverless cars. And these are things that the industry is working on and continue to be a thorny set of problems.
Yeah, I would agree with all of that. And I would just add, when I work on high-level governance issues in neurotechnologies, one of the issues is we use phrases like neurotech, AI, Internet of Things that we don't have standard definitions yet. So writing actual rules becomes incredibly difficult when people have different images in their mind. Definitely agree with the Fourth Amendment. There's been First Amendment concerns, and specifically in neuro right now, there's a lot of talk on national security issues, both from hacking to data collection, data sharing, and we see kind of rise in protectionism amongst countries with personal data.
I would say that the world I live in with facial recognition primarily, we don't really have problems with AI. We have a lot of problems with people and their perceptions. And I think that there is a significant and detrimental level of ignorance in the population that leads to a reaction of fear. And those fear is typically not very well founded. And so I would say that there's a significant defaulting to believing the sci-fi story and all of those things that come with that, which is just simply not reality. And I would say the other thing about concern about surveillance, I have as much concern about misuse of technologies as anybody in this room. And the concern about surveillance of us is ironic because most facial recognition applications are not correlating your data to your identity. It's simply creating a unique template of a face and basically not a lot different from the CCTVs. However, I would argue that probably most everybody in this room has a smartphone. And that smartphone is taking data from multiple different data points and reporting it out and attaching it to your identity, telling you where you've been, what you've done, all those sorts of things. And so if you're concerned about surveillance, you shouldn't have a smartphone. And yet you're concerned about facial recognition, which actually is not doing surveillance. So my comment is about AI. There's a lot of things we need to be considering here. But I think our biggest challenge is to educate and become informed and make decisions based on facts.
Thank you. Okay, so given that there seems to be a pretty wide range of problems between each of your areas of work as it applies to AI, what sort of... Oh, you can't hear? Hello? Okay. Sorry about that. So given that there's so many differences between the problems you have each articulated in your areas of expertise, as well as some similarities, what sorts of soft law approaches can be used to address or govern them?
Yeah, sure. Well, I think it's important to begin with the acknowledgement that soft law is not a binary affair. As scholars here at ASU have documented in so many reports, soft law is best viewed as a part of a continuum, a wide range of different ever-changing governance options. It's best to think of soft law mechanisms as sort of more pragmatic, experimental governance rooted in incremental learning. And so there can be a lot of different approaches. And it can go by a lot of different names. I have a list in my latest paper. I've got a big paper I recently did on governance of AI. And I was just shocked by how many names I found, or monikers I found, for soft law in the literature out there. And so just here's a very rough list of soft law by other names. Adaptive regulation, agile governance, outcome-focused policy, co-regulation, flexible regulation, policy prototyping, experimental governance, hybrid governance, and entrepreneurial administration. I love that last term. That term was coined by the current Attorney General of Colorado, Phil Weiser, who, as many of you know, used to be the dean at the University of Colorado Law School at Boulder. And he has a wonderful paper on entrepreneurial administration, but you never hear the term soft law in it. And so I think the key thing about all of those frameworks or framings of soft law is that they're clearly an acknowledgement of something about hard law gone wrong, that, you know, the one size fits all sort of top down overly rigid approaches that we've seen sort of get ossified in various systems and bureaucracies just no longer are adapting at the pace of change. And as Gary and his colleagues here have talked about, the so-called pacing problem that pervades all of the issues and sectors that we're covering. And so something's got to change. And so the question is, like, how do you get some coherent language about it? But everybody seems to want to be their own, like, have their own branding of soft law. It's like everybody's like their own, like, madman advertising agency when it comes to soft law. And like, no, we've got the right brand, we've got the right term. But really all roads lead to the same thing, which is a more flexible, adaptive, iterative approach towards governance. So I'm happy to talk more about all the other types of tools and mechanisms, but I'm gonna let my panelists continue on in that vein.
Yeah, I would just say I agree with all of that. I would say that also when you're talking about an emerging technology that's intended to hit the consumer market for mass purchase, there's a real incentive for industry players to actually work collaboratively to build guidelines or to establish certification and accreditation standards because a disaster from one company can be devastating to the others. So if Tesla has a series of very high-profile autonomous vehicle crashes, that's going to be bad for Volvo, that's going to be bad for Waymo, that's going to be bad for everybody else. And so there is an economic incentive, I think, that drives companies to work together to regulate themselves even before the government can step in, just to save their own market from the recklessness of key players.
Yeah, I was going to say something similar. I think there's a lot of opportunity, especially in nascent technologies, for industry to take a lead, hold each other accountable, set internal precedent. I was talking to a neuroengineer who's now turned policy person who he was doing work on black boxing, and now some companies are saying we absolutely can get this information and putting it out there. There is now a move like that doesn't look good in court when you are the company that's choosing to not participate in that scheme. So I think economic incentives are probably key at this point.
The moderator of the last plenary session last night had a rule. He said that you can't agree with other panelists. I'm going to break that one right now. I agree with the issue around flexibility and adaptability. I'm a science person by background, and actually I believe what Darwin said in a rapidly and changing closed environment, and that is it's not really the strongest that may survive. It may not even be the smartest, but it is certainly the most adaptable. And I think that adaptability in what we're talking about right now is a key element. And that adaptability is certainly the recognition that there's every flavor of AI, machine learning, all of these different technologies that are emerging quite quickly. I think the solutions have to then be not necessarily trying to lump by a particular technology. That's kind of an easy hierarchy to try to do things. But more importantly, what we use in the software world is use cases. What can I use this for? What are my guidelines around how I use things? And making those use case and the guidance that you have around those use cases transparent. I completely believe that transparency is a wonderful tool to create credibility and support and trust. And so I think that the issues around adaptability and use case identification are fundamental in how we work out these guidelines. I think the second issue that we're not doing very well, but is a historically valuable approach, is the risk versus reward conversation. And, but pragmatically really understanding and identifying what the risks are and what the potential rewards are. And so I'll use a case in facial recognition, a little bit familiar with that one. It's commonly used across all kinds of different use cases. Open your phone, easy one, one-to-one matching, easy. Good reward, probably not so much risk. In the retail sector, facial recognition is being used for customer optimization, tracking around, identifying you walk in, as you phone your phone, those sorts of things, that's being used. Personally, I would say that I think that you should have that person's authority in writing and approval to do that because, that sort of thing. Now, on a flip side, if you're deploying that same system for security, that's a different issue. And very few individuals we found are willing to sign up as criminals to say, yep, I'm going to come in and rob your store, but here, you have my permission to take my face rec. And so same technology, same deployment, but different use cases really have different guidelines. And so the risk versus reward issue. And in this country today, we have an absolute epidemic of in-store violence and theft, and that is having a significant impact on where we can shop and what we can do, and creating, in fact, food deserts because of stores closing in high violent crime areas. So that's a big risk not to do something. So that's kind of my comments.
Okay. So you each sort of described these different soft law approaches, and what are the sort of formal mechanisms that can be used to address them? Like I know, Dan, you talked about facial recognition. Tracy, you tend to study certification, or at least recently. So what sort of, I know these are a few different mechanisms, but what else is there? And how does it work? And how can you, and how can you operationalize these sorts of things?
Sure. Well, what Dan was getting at was one of the 6 key buckets of sort of soft law mechanisms that we've identified. It really is about risk communication, which is part of a broader bucket, which we'll just call education and awareness building efforts. And a lot of different agencies and bodies are engaged in this. The FDA, for example, has done a lot of work on risk communication in its context and published multiple reports about like communicating risks, technological risks to the public, and talking about risk trade-offs. So that's an important bucket. That's one major soft law mechanism. But I think the leading one today, and it was particularly tapped quite a bit in the Obama administration, is multi-stakeholderism. Multi-stakeholder efforts where government brings people to a table, talks about hammering out sort of best practices, which is the second bucket I'm going to get to in a second, of like how to govern a certain sector. So best practices and voluntary codes of conduct is another mechanism, and a big part of the multi-stakeholder process is trying to get industry and other stakeholders to come to some sort of an agreement about operational best practices or sensible guidelines, ethical, sort of baking in ethics by design or safety by design or privacy by design. Been a huge range of government efforts on that front. A fourth bucket would be agency guidance documents, and we see this happen all the time. It's not a new thing. Agency guidance has been a thing for a long, long time, as all of you who cover admin law know, but it's expanding and expanding rapidly. It's a very far more rapid, iterative process now of agencies doing guidance on the fly, so much so that they sometimes do it in blog posts and in tweets. I once had an interaction with an FTC official who was tweeting out some sort of guidance issues on Twitter, and I said, does this constitute official guidance of the federal government on this matter? And it's really, really hard, by the way, to cite tweets in the Blue Book format for like when you write that up in a law review article. But that's happening in real time, and industry and other developers pay attention. And I think those were all the buckets. Oh, informal consultations is the final one. There's always been this discussion among regulators and other government bodies, like, come in and talk to us, and let's sort of like hammer this out. But that's happening more than ever. You hear this, like, let's have a conversation about fill in the blank. And it can be a more official, multi-stakeholder thing, or it can be a government body or an agency calling in a particular company or trade association or somebody else saying, like, have you given this some thought? Now, don't get me wrong, there are problems associated with all 6 of those things that I just mentioned, and some of them fall short and don't do enough, and sometimes they need to go further, and some of them need to be hard law. But the reality is that those are the types of adaptive, entrepreneurial, experimental governance mechanisms that are being utilized in sector after sector, industry after industry, and agency after agency.
So I'm really interested in certification and accreditation as a form of soft law regulation. And I've spent the last year researching regulation of another kind of vehicle that I hope is not too similar to an autonomous vehicle, and that's roller coasters. If you want to go down a really weird soft law rabbit hole, I highly recommend researching regulation of amusement parks, because it turns out they're not regulated by the federal government at all. And in many states, they're not regulated by the state government either. And at first glance, that's enough to make you want to never take your kids to Six Flags ever again. But it turns out that actually ride safety is extremely high in the United States. Only 1 in 42 million visitors to American amusement parks are killed by rides, which is a really great statistic given how many amusement parks and how many rides there are all across the country. And the industry has achieved this nearly entirely through certification and accreditation. There are a really shocking number of bodies of amusement park owners, of ride developers, and ride engineers that have established a really extensive body of voluntary guidelines with an extremely high level of buy-in from amusement park owners and managers. And it's worked, and that leaves me really optimistic about this model for other industries for which safety is going to be a key determinant of consumer buy-in. And so, yeah, so the roller coasters actually make me more optimistic about our ability to regulate driverless cars.
I would just add, neurotechnology as a use of AI and machine learning right now is being developed primarily in smaller companies that will inevitably be bought out by larger companies because that is the model. I have a pending article that talks about all the guidance documents for neurotech, which doesn't include just data guidance documents, AI documents, and they're ad nauseum with very vague principles, and none of the small players that I talk to have read or seen them. They don't have teams following up and briefing them yet. They're working on just kind of keeping afloat, but they're building foundational technologies. A few of them will be first to market and will kind of win the space and sell out. So I think they do understand not being liable, not being sued, not breaking rules. So I think the more we build that component in, and when soft law can be tied to liability, really you have something that kind of keeps everyone engaged.
Well, I'm going to probably have my first disagreement. I built a couple of different companies in the software industries, and collaboration and openness and transparency is an enormously powerful tool in creating accountability for your product and how you do that. There's an offsetting issue, however, and that is the plaintiff's bar. And that is, we've seen oftentimes information being withheld or concealed simply because of fear of litigation. It's interesting, I think it was this week I read an article around an anonymous surveying of Fortune 100 companies, and a majority of those companies' CIOs were saying that they were concealing and not reporting cybersecurity intrusions because of fear of plaintiff litigation. That's not helpful. That is really not helpful. And I would argue that there has been another pattern that we saw that had the same issue in the medical industry. And that is we have mistakes made in operating rooms, that sort of thing. Everybody knows that. And the problem with what was going on is one doctor would not share his information with another. And so many years ago, AMAs, some insurance groups, and all kinds of folks got together and said, okay, let's get some immunity passed so that we can actually gather the data around close calls, encounters, anonymize that data, and create a body of knowledge that we can all learn off of. And I think that was enormously powerful in sharing best practices and changes that needed to be made in operating procedures and that sort of thing. And it created a body of knowledge that allowed everybody to prosper and move on. I think that fear of litigation and plaintiffs is going to stifle some of these things that we're doing unless we create some sort of ability to gather information, gather close calls. In the world of public safety, that's what we kind of call things that almost go bad, but we can learn from, and sharing that information internally. Because I will tell you, I think the industry wants to continue to evolve their efficiencies and their safety and all those sorts of things. But if we keep closing that data and where we've made mistakes from others because of the plaintiff's bar fear and the cost of that and the regulators, that's not going to help us move forward.
I would just add that I think that the plaintiff's bar issue is pretty technology dependent. So autonomous cars obviously have a very different bar, medical tools using AI than, like wearable direct-to-consumer neurotechnologies are just collecting. So they know they're not, there's no rules, they're more fear of regulation, so understanding how to build it in.
Okay.
So that's pretty dependent on where.
Agreed. However, let's just take an example, the Illinois BIPA law. You know, Illinois basically is requiring that any biometric data that's gathered has to have a pre-approved informed consent in writing. Okay, period. That's it. So what has happened out of that? How has that protected consumers? And the answer is that several years ago, we knew in facial recognition that part of the problem of accuracy was poor diversity in the training data sets. Candidly, when facial rec first came out, the only really annotated data sets we had for training was the American celebrity list. Believe me, Brad Pitt can be nowhere on this planet that we won't be able to identify him immediately, okay? However, it did not have good gender diversity, it did not have good ethnic diversity and those sorts of things, and so we trained on data that was insufficient. And these are, I'm talking about the 8, 10-year-old deployments. Valid criticism. Okay, that's all changed. Currently, if you look at the NIST testing for the top 150 facial recognition, there's no statistical difference between demographic information and accuracy. That was a recognized problem, solved, moving on. However, to assist that process, IBM, years ago, collected data off of Flickr, people putting their images on, they annotated that, and they gave that data set to everyone for free to use as training data. Nicely diverse set of training data to improve the technology and help everybody along. They got sued. They got sued in Illinois because someone in Illinois said, oh, you've got my picture off of Flickr, and now. And so the result of that is, and I can't remember the exact number now, maybe somebody in the audience would help me out. Google how many BIPA lawsuits have been filed in the last 10 years. I think it's somewhere close to 50,000 class action suits. This is a plaintiff's bar smorgasbord that has stifled the advancement of the industry to the benefit of people. The other one, Subaru, used some biometric information on the dashboard to indicate drowsiness, give you a little vibration in the seat to wake you up and that sort of thing. They did not get the approval of every driver in their Subarus to do that, got sued, lost, had to pay tons of money. This is not helpful for us moving the technologies along when we have good intentions. And so the plaintiff's bar, I agree, is important in many aspects of keeping things balanced. But man, it's sometimes very not helpful.
You know, I just briefly want to make one point on this, that Dan's making an important argument about the relationship between tort law and emerging technology. You know, Congress has dealt with this issue in numerous contexts in the past. If you go back and look at the National Childhood Vaccine Injury Act of 1986, you take a look at what Congress did controversially to limit firearms liability, you take a look at what they've done in the context of aviation, and then, of course, most importantly, in 1996 with Section 230 in social media and digital liability, right? This is a very controversial matter right now. So Congress has sort of put some limitations on liability for certain technologies or sectors. But today, I think things are heading in exact opposite direction. And if you listen to Tuesday's hearing about governance of AI, Senator Josh Hawley, a notable conservative member of Congress, was salivating at the prospects of opening up the floodgates of litigation against foundational AI models, and said basically, bring on the trial lawyers. And he said, yeah, we might not get it passed, but the very threat of it alone might have the sort of chilling effect he was hoping for. This is a conservative member of Congress, you know, agitating for basically lining the pockets of trial lawyers, not exactly the most conservative of constituencies. So the world has changed, right? And I fear that world. I think this is the world we're moving into. And, you know, if Section 230 gets tweaked or these other liability regimes, or we have one for AI, it will go in a very different direction than protections against tortious liability. It'll go in the direction of opening up more claims.
Excellent, thank you guys. So to Dan and Tracy's point, each of you sort of mentioned that transparency, information sharing, and other issues should be addressed through some sort of governance. Maybe it's soft law. But Tracy, you talk about certification, and certification has been used to address these information sharing and transparency issues, among others. Can you sort of explain how this certification mechanism works, and if it can be applied to AI, or how you're seeing it sort of emerging in this field? And sorry, if others disagree on like the usefulness of certification, please talk about it.
Yeah, I think it's so industry dependent, right? And industries vary in their level of buy-in for certification processes. There have been industries like the amusement park industry with an extremely high level of buy-in. Everybody thinks it's great. There are industries that have experimented with much less success. I think one of the difficult things is that good certification programs require transparency, and that oftentimes requires revealing intellectual property or details of your production process, which some companies are very, very hesitant to do. And I think that's always a sticking point when we're talking about certification or accreditation, is companies being very protective, understandably, of their own intellectual property. Again, I think that the market forces there incentivize different behaviors depending on what it is that you're talking about. Are you talking about something that's eventually going to be hopefully sold to all consumers everywhere? Are you talking about neurotech or something that's aimed for a very particular specialized industry? And so, yeah, I think it's hard to draw sort of broad conclusions. You have to sort of look at the specific industry and how likely people are to share.
This gets back to that risk versus reward conversation, and I think that Tracy's absolutely right. This is going to be a wide gradient and variance of those sorts of things. Previous company I built was engaged in the public safety sector, and accreditation has become a very, very powerful, effective methodology of creating some consistency of performance across 18,000 state and local police departments in this country. Many of which, I don't know, you guys know this, but 50% of every police department in this country is under 10 men. Now, if you think about a 10-man shop, they've basically got 1.5 people on duty at any given time. It's an extraordinarily thinly resourced kind of application. And so in that situation, accreditation really created some professionalism and guidance that they did not have access to typically. So really, really effective. In this case, I think we have some similar issues, and accreditations or those sorts of approaches. Our company has chosen to basically create our own governance models that we impose upon our customers. And we have the ability to delete their software or delete their data if they are in non-compliance with the guidelines we have. And much of the governance process that we built is really based around what I believe we're headed to, which is a level of governance and transparency and accountability that we see across public safety in this country. That is, if you want to put someone into an enrolled database to alert on a facial recognition, as an example, you really need to document the probable cause of why that individual is in the database. That has to be documented. It has to be verified by a second individual. You can't have just one individual put something in. And then the auditing of that, who uses that? We've actually got some really good standards that have been built previously on how we access data, the auditing logs and the verification of how that is. Those things should be transparent. We should all be basically understanding what are the guardrails that have been put in place. And in our case, candidly, our customer base has been very, very grateful that we put these standards into place and that they can share that with their customers, that these are the standards that we're following. And so this issue about evolution and how quickly we can evolve along, I'm a pretty big believer in the marketplace. I think that with many of the companies that we deal with, they are consumer facing. They're extraordinarily sensitive to their brand trust, and violations of their statements, they take very, very seriously. So their self-enforcement goes beyond the threat of a regulatory environment or those sorts of things. It's really about their most important one that they want to be held accountable to, and that's their customers. So I think that there's some opportunities there to really create, as Tracy was saying, the transparency, and as importantly, building in the functionalities of accountability.
I just have a brief comment on the self-certifications, labeling efforts and things like that. A few years ago, Gary asked me to write a paper for him that went into geometrics on the history of soft law in the ICT sectors, information communications technology sectors. And I explored 4 different case studies, one of which was sort of media content labeling self-regulation. And of course, there we have, for movies, the MPAA system, and for video games, the ESRB system. These have been generally considered to be quite successful self-regulatory schemes, although not without some controversy or flaws. Both were pressured, came about because of pressure from government trying to directly censor movie content and then video game content. So there was a bit of a nudge there, if not a shove from government, like you better do this or else. Of course, there was a First Amendment fight there too. But the reality is those systems have been in place for a long time and been fairly effective. By contrast, there was another effort for self-labeling of the internet, most of you have probably never heard of, called ICRA. That was an attempt to have machine-readable metadata embedded within all internet websites to have content screening at the device level, so that you could type in, like, I don't want to see any porn, I don't want to see whatever. The website would be self-labeled as having such things, and then you could screen them. That effort failed miserably. And it failed miserably because it didn't scale. It was just the sheer complexity of it, the scale of what was happening was overwhelming. And this is the thing. I mean, some systems scale up better than others. For movies and video games, there's only so many movies or video games that are made each year. You can actually count them. Websites, good luck. And social media, how do you even begin, right? So there are 2 different approaches. And with the world that we're moving into of, the computational revolution of AI, machine learning, robotics, this gets really tricky. And it's also tricky because in the old days, what really made the old MPA ESRB systems work for movies and video games is that you really only had a handful of key companies or providers that made the key decisions. And so you only had so many movie studios and you only had so many video game providers. And then importantly, in the video game context, you only had so many consoles. What made ESRB machine data readable labeling and filters work is that Microsoft, Nintendo, and Sony said, we'll do it. And then they put up a prompt when you, as a parent, got a video game system, well, would you like to turn on these parental controls and these filters and use them for your children? That worked. But it worked because we got buy-in from a handful of key providers. Who are those providers in the AI context? Where are they located? Right? I mean, this is what's really going to be complicated about scaling up soft law and self-certification regimes for AI. It doesn't mean that I don't think it can happen, and it is happening, but there's an enormous diversity of players, actors, and they're international in scope, and the volume of the activity is astonishing and changing every day.
I would just add to Dan's point about internal governance strategies. The plenary yesterday, end of day, focused primarily on mergers and acquisitions as far as antitrust. The paper I'm working on now for a grant is actually on ways that companies can bake in corporate governance in the actual negotiations of merger and acquisitions rather than dealing with antitrust, which either, whatever side you're on, it either rarely wins or isn't an effective tool. So I think there is a lot of room for corporate governance to take a bigger lead.
Adam's comment here about buy-in, let's not discount the power of the consumers in this conversation. And if we can adequately inform, factually inform, and get folks to help support their purchasing power into companies and methodologies that support this process, I think the adoption rate will be staggering compared to a regulatory approach. Because companies are pretty typically responsive to the folks who give them money. And so let's make sure that that power within the capitalistic system is leveraged into some of the things we're talking about. I think that's probably one of our opportunities that may be coming out of this conference is how do you actually create an advocacy group for this sort of thing? We have advocacy groups for everything in the world, right? But do we really have an effective group who is educating, factually educating, in a nonpartisan way, in a factually accurate way, helping folks then support this? I think Adam's given a couple of examples that was effective, movies, kids stuff, but how do we start that?
It's a good question. It's exactly what I'm going to ask you next, actually, is how do you think we should create a public forum or something similar to discuss and test the various types of soft law approaches without getting named and shamed if one doesn't work as planned?
Well, luckily, there are some agencies in the United States at the federal level that do a very good job of bringing parties together to talk in a collaborative sense about emerging technology problems. At the U.S. and the Obama administration years, and even continuing on in the Trump years, those two administrations did not agree on much. But actually, there was a surprising amount of coherent thinking or approach on a lot of sort of soft law governance for emerging tech, starting with the fact that the Department of Commerce, the NTIA, National Telecommunications Information Association Administration, basically was coordinating multi-stakeholder processes and having ongoing educational efforts and trying to coordinate among diverse players, bring them in a room, have an ongoing dialogue. Some individual agencies have done a good job doing this on occasion. It just depends on who's running the agency. The Federal Trade Commission has done some wonderful things in the past on bringing together multiple agencies and multiple stakeholders to try to hammer out best practices on a diverse array of things. I was involved in testifying on one. It was a collaboration between the Federal Trade Commission and the National Highway Traffic Safety Administration on best practices for connected vehicle cybersecurity. Brought the agency people together, brought the industry together, brought other stakeholders together, hammered out best practices that to this day essentially are the baseline operational principles for cybersecurity and connected cars. The only notable holdout to that was Elon Musk and Tesla, who's always doing kind of na-na-na-na boo-boo, thumbing his nose at everybody, you know, and whatever. But the reality is that for the most part, even he and his company are abiding by those principles. So there can be forums like that. It just depends on who's running them and their attitudes toward it. I would say the current FTC is going a very different direction and is threatening more of a hard law kind of an approach. And I think in the age of AI, I think we're starting to see a change in the tone and tenor of how some of these agencies approach these things. But it's very context specific. It just depends. I'm always noting the differences even within agencies. At the Department of Transportation, you have the Federal Aviation Administration on one hand, and you have NHTSA, National Highway Traffic Safety Administration, on the other. Very, very different approaches on a lot of these things. NHTSA is far more flexible, soft law oriented. FAA is a little bit more hard-nosed, a lot more hard-nosed about these things, granting flexibility and waivers at the margin on occasion, but very quietly. NHTSA bringing people together, trying to hammer out sort of best practices and stuff, rough rules of the road that aren't formal rules of the road. So it's very, very individualized and context specific.
I would say that members of the general public are doing a great job on their own of creating forums where they can discuss these issues. One of my favorite Facebook pages, to give you a very low-level example, is called National Snakebite Support, which I highly recommend that you join if you're on Facebook. And it's a group of doctors and people who live in areas frequented by poisonous snakes that talk about best practices for snake bites. And it turns out that a lot of medical professionals and ERs are not well-versed in this very important topic. And this one Facebook group that I've been following for 2 years has been slowly changing protocols, particularly in hospitals in Texas and Oklahoma that get a lot of snakebite victims, really solely as a result of the activity and advocacy that's coming out of this, Facebook group that started with 5 people and now has tens of thousands of people. And that's not a consumer product, but you see similar things. There are subreddits devoted to particular products in particular industries. There are Facebook groups. There are Twitter discussions. And so I think I'm pretty optimistic that the government doesn't need to be involved in creating conferences, although that's great. I think the general public is finding, kindred spirits amongst themselves with the social media platforms that we already have available.
One of the great things about this country is we live in a significant petri dish of experimentation. We've got, 50 states that are trying different paths on all kinds of different things constantly. And we get to observe failures, successes, new information that comes in, and I think that would serve us well. The challenge with that, however, is how do you get that information together? Tracy talks about perhaps a Facebook site for snakebite docs and that sort of thing. My oldest son is actually in that profession and has used that. But I would question the trust factor on some of those platforms, just candidly. And so perhaps what is really needed is more of an entity, if you would, Gary's group or whatever, that is actually able to factually compile the successes and failures across this country of what we've been trying. And highlighting that and summarizing that and creating that as a wider spread opportunity. One of my volunteer positions is I serve on the board of directors of the National Policing Institute. It's the largest think tank in this country, funded 50 years ago to really explore innovation in policing. And out of that group has come most of the major changes in policing in the last few years that have been quite helpful for our society. And that's exactly what they do. They do case studies and reviews, post-action reports throughout this country. And they make those public, and they are unvarnished. Where cops have made stupid mistakes, they call them a stupid mistake. Where there's been a success or an avoided action because of some creativity or some other thing, they highlight those as well. And those best practices and that information being shared in an unvarnished, factually based, good, investigative manner has been unbelievably successful in helping change behavior across this country with all these little tiny agencies who don't have the resources to understand. I think in some similarity to our case, much of the AI innovation, much of the machine learning algorithms, much of this is being developed in really small little shops in someone's garage. Those organizations, and I'm very familiar with them, do not have the resources or the bandwidth to be really taking all of this kind of soft law governance application and figuring it out by themselves. They need help. They need a forum. They need an application that they can go into and find information that helps them bake things in, as well as the arguments of why that would be an important element for their success.
Thank you. Sorry, did anybody else have?
I was just going to mention that what Dan's getting at and what our panel's talking about here is like the need for coordination, maybe at somewhat of a higher level. You know, a couple years back, Wendell and Gary had an article talking about the need for GCC's governance coordinating committees, which were sort of like what I'll call super quangos, like quasi-autonomous non-governmental organizations that could, you know, span the globe and provide guidance, governance guidance, best practices, and so on, and coordinating role for emerging technology sectors and novel issues. And I think there's really something to that. The question is, what are these things? You know, who are they? Who runs them? You know, that's the challenge. Well, I think we're supposed to mention the fact that we're doing some grant work here for Gary on these issues. And so the paper I'm going to be writing is going to be about AI soft law in the medical space, and what the FDA in particular have been up to. And so I found one of these things, Gary and Wendell, you'll be happy to know. The International Medical Device Regulators Forum has risk categorization principles for machine learning and AI-based medical device software applications. And this risk framing and framework that they've created at the global level is they're trying to implement this in a flexible way at regulatory agencies across the globe. So this is a sort of a GCC, if you will. I don't know how effective it'll be, but it's created a framing. It's created a framework within which we can talk about flexible governance of advanced medical machine learning-based diagnostic and treatment tools. So I'm going to be studying that. We'll see what the status of that is. The FDA currently has guidance that is open right now for consideration and public comment on this very, very issue. And it was open, I think, on April 4th, and the comments are due in late June. So this is a real-time moving thing that's happening right now in this world. And so maybe there is some hope there for coordination.
I'm going to add a shameless plug. So I started working with a think tank, and it's some ex-academics and neuroscientists. And we've had a couple of really successful programs this year because our goal was to just bridge gaps in education. So we helped, and Gary was there, coordinate the first time industry has ever been invited to OECD in Paris to talk about large scale. We just had a export controls meeting at Department of Commerce where we had industry, patient advocates, and government officials in one room. The goal was not for us to advocate a point, it was to get conversations going and voices heard. I don't know that I have a great answer for public engagement yet. That's something that's one of our big goals to work on, but I think there's a lot of opportunity for those kinds of bridging and open communications.
Excellent, thank you. So you sort of all touched on this next question already, But I'm curious what you all think the role of international organizations are in all this. It's sort of been touched on a little bit throughout. Dan, you mentioned that police services sort of look to think tanks here or associations, but also mentioned that they should have something to look to, something broader. Should that be set by some international association or organization? And similar for other areas.
I think in the realm of figuring out, or let me rephrase that, gathering the success cases and the failures are I think, really valuable on an international basis. And I'll give you an example. In this country, when we deploy an application for facial matching in a customer's environment, the database of enrolled persons of interest is only that customer's database, not shared with anybody else. Don't bring in police photos, nothing else. It's just the incidents that have occurred with that customer that they've documented and have evidentiary reasons to alert when that individual comes back into their store. So it's a very isolated, well-controlled, privacy-centric type of application, primarily at the insistence of many regulatory bodies. Now, we share some common law evolution with the UK, and so we've kind of come out of the same set of principles in how we develop law. In that country, exactly the same deployments for face rec in retail environment requires by law that all of those companies share their database, and that becomes an aggregated database of persons of interest. And their rationale is that if one store has a known bad offender and this other guy does not, that becomes a disadvantage to the one who doesn't have it, and it's an unfair competitive advantage for the one that does. And so they require sharing of those databases. To me, that's fascinating. We've come out of exactly the same foundationals of how we look at law, but we've reached two completely different conclusions on how to interpret that. Is one better than the other? I don't know. I could argue both ways. But maybe the international opportunity of this, what works, what doesn't, what are the ramifications, what are the indications of that, those could be very valuable from us on an international basis, particularly with those who we have very, very similar economic structures and commonality in some presumptions about law and individual rights and privacy. I think that there's some great opportunity that could be done there. But not the regulators.
I'll just mention a few other things on the AI front. This question of international coordination of governance is an active concern right now. I've just finished a big paper on it. I'm trying to go back through some of the list of some things that are being formulated. But basically, there's a lot of discussion about how we might be able to create the equivalent of what we already have in the world of nuclear energy and aviation with various types of organizations that already exist, like the IEAA and the one for aviation, whose acronym I forget. But there's multiple efforts afoot right now, multilateral, but really more mini-lateral. Things like the Digital Nations Group, which is a group of like 13 or 14 nations have come together to try to coordinate on these issues of artificial intelligence and emerging tech governance. And there's now an OECD effort called the Global Partnership on Artificial Intelligence, broad multi-stakeholder kind of effort that had its first meeting in 2020. Again, these are kind of like, again, going back to Gary and Wendell's GCC models, I think these are the kind of bodies or efforts that are going to engage in a lot of this coordination. I think the problem is that the broader you get with an emerging technology governance issue, the harder it is to have effective coordination. And if you're talking about coordinating like aviation safety or nuclear safety, that's one thing, right? There's a very clear target there. There's there's metrics. You can kind of like measure this and study it. AI safety, what does that mean, right? You want to talk to the Chinese or the Russians about disinformation and think you're going to get agreement? Good luck, right? I mean, this is really, really hard. And when you talk about existential risks of surrounding emerging tech, which are very real, I'd like to believe we could get the UN to set up an effective body to monitor and sort of address these issues. But folks, the UN just allowed Russia to take over as the head of the National Security Committee after invading Ukraine. And last year, in the most astonishing development, I believe, in UN history, we allowed North Korea to take over the Council on Nuclear Disarmament. I mean, I don't even know what to say to that. They're the biggest nuclear pariah state in the world, right? I mean, are we going to have Iran running like AI safety, or, you know, China or so? I just have a very hard time believing that that kind of an international governance approach is going to be effective. We need to have channels of ongoing communication and dialogue about very legitimate risks surrounding artificial intelligence and robotics, especially lethal autonomous weapon systems. I just don't know if we're going to get it from our traditional agencies and organizations.
Yeah, I would just add to that. I agree with everything Adam said on IOs right now, but I think they play an important geopolitical role or vision. But the relationships between human rights, national security, and we have to remember this is a big part of global supply and global trade right now. I think it'll be fairly limited unless we identify a use of AI that parallels the nuclear bomb. Otherwise, this is going to be outside of their ability to implement.
Thank you. Okay, so most of you sort of also touched on this, is that most of these soft and hard laws that have been purported tend to focus more on these large size firms rather than small or medium. So do you think these major AI players play more defense than offense with regard to their contribution to soft law efforts compared to middle or lower player counterparts? And if so, how might we get them to reduce their defensive stance?
A little bit of both, depends on the firm, depends on the sector. There's a whole heck of a lot of industry bickering right now on the AI front. A lot of it goes back to what Lucy just mentioned about sort of like the context-specific nature of some of the issues or concerns that are out there. But companies and trade associations right now are in the let's throw each other under the bus phase of this issue, not really coordinating very well, and there's just daily holy wars between Microsoft and Google alone on this front. And so there's a real lack of coordination, I think. And a part of it just goes back to this high-level amorphous nature of what we're trying to get our heads around or our hands around in terms of regulating AI when we can't even define that term. The General Accounting Office recently came out with a report expressing frustration at the fact that there is no consensus definition of artificial intelligence among any of these government agencies, industry companies, whatever else. It's just, it's really, really hard. So it's a frustrating moment, and this is what's leading to, I think, a lot of concern among policymakers and an avalanche of now hard law regulatory proposals because of the frustration of like soft law not scaling up fast enough or effective enough.
I would agree. I would say strategically, it makes sense for AI players who are staring down the barrel at government regulation to go on the offensive and to create governance structures or certification standards or guidelines to hopefully prove to the government that they don't need to be regulated. And I think as a former products liability attorney, that can also help limit your exposure to liability. If and when you're sued, you can say, look, we were leaders in the industry in developing safety standards and guidelines, and we have, promulgated those to our competitors and everybody's accepted them. That's a great look if you're staring down the barrel, not just at regulation, but at consumer lawsuits. And so I think in a lot of cases, an offensive stance is going to be the best way to go.
I'm a dedicated pragmatist. And the pragmatic observation that we're in is that we're in an enormous arms race right now in AI for talent and data. I mean, those are the two things that we build our systems on. And if you look at the large entities, let's just look at the talent. 2 years ago when I was trying to recruit some 2-year experienced ML engineer, 2 years, that's not, that's not a lot. But I was competing with offers from Amazon, which were $300,000 downstroke for signing up and $300,000 a year for 3 years guaranteed, no matter what. So $1.2 million contract for a 2-year experienced ML engineer. I couldn't compete with that. There's just no way. That dynamic is shifting a little bit right now, and you hear about the layoffs at Microsoft and Amazon and others. I will assure you that none of the engineers are getting laid off. None of the engineers who produce. None of the engineers who actually know what they're doing, because we've been interviewing them. The other side of that is the arms race around data. I mean, talk about AI or all those different things. None of this works without massive amount of data. And where does that data come from? Where is it controlled? Where is it distributed from? And where is it accountable to? That, in my opinion, is going to continue to be retained within large companies, simply because of the scale and the cost of processing and access and distribution. So they have a high degree of interest in being engaged in this, but I don't think they will. And I don't think they will because they've got the high position in a defense, and they can defend that. And so I believe the only opportunity to have them engaged is the customer base. And so many of our customers are large companies, and they will have data centers and that sort of things with the larger folks. And as the customer base requires these things to be adopted and implemented, that will force, I think, the larger companies to engage and become proactive about it. Until that happens, I don't think it'll take place because they've got a very, very defensible posture and don't need to. You know, when we saw in 2020, when there was a significant social narrative around backlash on facial recognition, Amazon, Microsoft, and Google all said, we're stopping. We're not going to do any of it. We will not deploy this technology. We will not do it. So they could withdraw from the market. Now, I happen to know that they're continuing the research, but when it becomes safe to play again, they'll be back in. But they have the opportunity to stay on the sidelines and be in a dominant position for quite some time. The only thing that changes that, in my opinion, is the economics of the customer base requiring it.
Thank you. Okay, so I'm mindful of time to leave time for questions. So with all that's been said about soft law and AI today and over the last and yesterday, how do you see this form of AI governance playing out? Is it realistic? Is it time to shit or get off the pot about it? What might lead to its success or failure?
Well, I think I've identified a couple of the reasons why we're in a problematic world right now on AI governance because of the diffuse interests and sheer volume of issues. And we need to get far more focused about what kind of governance. I think Lucy alluded to this, like getting more context specific, getting more concrete about actual real world problems that we can bring soft law toolkit to bear and address. And I think that's happening in some contexts better than others. But I think there's a real tension right now in the United States in government about the willingness to engage in this sort of pragmatic governance. I think that there's a lot of people on both the left and the right that have grown fundamentally skeptical of these sorts of tools and increasingly look at a lot of these technologies as a threat to them or their values or their political bases. I mean, if you've watched any congressional tech hearings in recent months or years, it's grievance politics all the way down, right? An airing of grievances about all the evils of the world of tech. And everybody seemingly wants to aggressively regulate big tech, whatever that means now, but for completely different ends and purposes. There's, but to them, the ends justify the means. We just need to go out there and get it. I was quoted in Politico today talking about where AI governance is going, and I basically said the social media culture wars are going to morph into the AI culture wars. And we're about to see a lot of aggressive attempts to regulate, but on very different grounds. The conservatives think that AI is just all some giant, anti-conservative woke conspiracy. People on the left think all AI is just hopelessly, irredeemably biased and discriminatory in character. And therefore, we must do something. Well, soft law can fill a lot of the gaps that hard law can in addressing that and doing something, but people are more interested in having concrete, right now, one-size-fits-all solutions. The bottom line is, it's just probably not going to happen because we know that for all the reasons I just identified, there's sort of a grotesque level of dysfunctionalism within our legislative body right now that prevents even common sense types of reforms from moving. There's been widespread agreement that the United States needs a baseline privacy bill for the past 10 to 15 years. We never get one. There's for the last 6 to 8 years been widespread agreement we need a driverless car bill to preempt state patchwork. We never get one. You know, I mean, I always, you know, I used to make bets with students at the university when I was working at George Mason. I used to say, like, pick any bill this session and tell me you think it's going to absolutely pass, and I'll take the opposite money. And finally, somebody at the university told me, Adam, you got to stop betting your students and taking all their money. And it's just not right. And I didn't like being on the winning end of those bets, but the reality is that we don't get anything through. We don't get any hard law. And so soft law is it. And so as messy and amorphous and frustrating as it is, this sort of decentralized pragmatic governance toolkit is, for better or for worse, the new operational norm at the federal level in the United States. Now, one caveat to this. That doesn't stop the state and local governments from doing their thing, and it certainly doesn't stop the Europeans from doing their thing. So the world of AI and algorithmic technologies is now going to get squeezed between the Brussels effect and the California effect. Those two things are putting the squeeze on AI innovators in a huge way. And the only action we might get at the federal level, in my opinion, would be, of a hard law variety, would be an effort to preempt or stop those efforts in some ways. But I'm still even doubtful. So soft law, for better or for worse, will continue to fill the gaps, but it'll be selective. It'll be very agency-specific, sectorally focused. You'll see action at the FDA, the CFPB, the EEOC. The EEOC just announced a new framework yesterday morning at 10 o'clock. The FDA's got the thing that opened right now that I mentioned. The Consumer Product Safety Commission is on top of this. You know, the U.S. federal government has 2.2 million workers, 15 cabinet agencies, 50 federal independent commissions, and 450 other sub-departments. It's crazy to think that we don't have a lot of regulatory capacity out there, and it's crazy to think that those agencies aren't actually actively considering AI issues. They are. And so you're going to see a lot more of this messy sort of decentralized soft law approach incrementally play out agency by agency. It's just very, very difficult to keep track of and make a coherent sense of. Sorry for blabbing there.
I think the conclusion you have to start with is this a problem that we need to address? And the answer is without question. Without question, we need to start understanding and putting guardrails into the use of the different technologies. I mean, I don't think that anybody really questions that any longer. But this elephant's too big to eat in one sitting. And so the concept of how big is this problem and how do we start nibbling away at this challenge, I think, has been reflected by every comment up here on the panel today, and that is this is very diverse. This is very unique by each situation. My argument would be, instead of trying to look at the technologies themselves, but really look at the use cases and how are you absolutely applying this. Those are probably guidance that we can come up with more quickly than we can. California has passed some legislation around use of different technologies, and they've actually said, yeah, you got to get somebody's permission to get their biometric template, unless it's for a security and life safety application. And so they've really addressed it from not only is it a technology, but is it, what a use case are you doing here? I think that's a pragmatic approach. Certainly better than Illinois just saying, nope, can't do it. I mean, that's naive. So the soft law approach, and the other one is then, you know, the regulatory environment. I have no confidence that we're going to get anything done in our federal government these days. We are extraordinarily politically partisan, polarized. And that does not look like it's going to get any better in the near term. And so our problem is not going to go away or diminish. It's actually going to be exacerbated. At the same time, we have a debilitating effect of the regulators to do something effective. And so how do we look at that? I think the soft laws approaches are the only approach, candidly. And it's a very big issue that is pressing. So how do we activate everybody in this room, people in our country, people who are the audiences of our customers? Those are the things. And I would think that once you have some larger companies who are not the tech companies, but the other companies within that depend on these big data sets and depend on what their utilization of many of these technologies will be embracing. My experience has been they want this. They want to be given the guidelines, informed, factual basis of how to comply. I think the commentary that, the fear about regulatory environment will prompt people to do that. I think it's the users of the technology, not the technology providers, who might be creating that force. And that's who we should help activate.
Yeah, and I would just add, I think right now we kind of talk about the soft law toolbox quite a bit. I think it's a really important time to define when tools work and where, like better articulate risk, what we're talking about, and what examples work when and where, so that it's not this amorphous toolbox.
I agree with everything that everybody said. I would just add that I think even among serious lawmakers, of which there seem to be increasingly few, I think there's a realization that conventional hard law mechanisms don't work very well in an industry marked by very rapid iteration. So even people who do want to pass meaningful legislation, I think, have to recognize that it's a clunky way of regulating things that are changing incredibly quickly. And so I think the government realizes this, the government knows that it needs a quicker method, and so I think there's necessarily going to be reliance on soft law as the only better alternative that we have.
Okay, thank you guys. So I don't have any more questions for you, but I imagine others do. So with that, we'll open the floor to questions for the next 15-ish minutes. Yes?
So assume that I am the leader of technology X. How would you address the claim that I am pushing soft law governance in my sector as a way to enact a barrier to entry that I didn't have to deal with? The way to keep others out of the market because I'm just raising the cost of taking in.
It's a great question. This is the proverbial fox guarding the henhouse problem, and it's a problem for hard law as well as soft law, right? The hope is that in a soft law context, you get more stakeholders involved in the process, and you actually get more collaboration among a diversity of players and parties, and you get around that problem. Also, the best thing about soft law would be it wouldn't lock in the system, because soft law wouldn't be as enforceable as hard law. Now, it may play out differently. When I mentioned the example of video games and movie ratings, you could say, well, it was effective. It helped us get ratings and labels on content. But you could also argue that it solidified the power of the 3 console providers and gave them a mini cartel, right? This is something identified in the report that I wrote for Gary in Neuroethics, is that there's a fundamental tension in terms of creating more effective soft law between competition and effectiveness. Sometimes you need a little bit of market power from some key players to drive a process. If we wouldn't have had buy-in from the top content companies and content distributors for movies and video games, we would not have got that system done. And this is probably why it hasn't worked for the internet, and it's going to be challenging for AI. There's sheer diversity of players. So this is a tension I've struggled with throughout my entire career, is how to balance this. But at least with soft law, theoretically, you have a more open-ended process where there is the potential for iterative change and flexibility built into it, as opposed to an ossified hard law system that once it locks in a particular provider of a particular process, it may remain that way for a lot longer. And then you're stuck with something that looks like what we had to deal with the taxi cab commissions refusing to open up taxi cab competition for 100 years in this country until Uber and Lyft came along and disrupted them, right? We tried for 100 years to change that process, but hard law was locked down by a handful of localized limo and taxi companies who owned the commissions. So it was only disruptive technological change that made it happen. In the soft law context, maybe that would have never happened because there wouldn't have been rules that said you had to have a formal license to actually operate a taxi cab or a limo.
I would say that hard law versus soft law kind of comparison, what we tend to do in hard law is create bureaucracies that need to continue to justify their existence, and so they'll come up with guidelines that come all the way down to the font size and the curling spacing of the text. I mean, it's absurd, right? And that's what he's talking about is how we lock in these things that are just amazingly strict and rigid and potentially benefit a few players. I think your question about, creating some soft law guidance within a market leader to create a barrier to entries, I say I don't think so. I think that it's what I'm doing currently. I am a market leader in the governance platform that we're developing within our little sector. I have no doubt and am aware that my competitors are going to be adopting same things. I say great, fantastic, because it's going to elevate all of us and it's going to create more acceptance and integrity of our solutions across. I'm willing to compete with anybody. And if they want to adopt similar issues that I'm doing in soft law as governance, I think that's terrific. I'm really happy that they are. So I would look at it a completely different way.
Yes, and then we'll go to.
Yeah, so Adam, you mentioned the hope that you get sort of a lot of people in the industry together. This goes back to something years ago. It got very popular, negotiated rulemaking, where an agency would bring in people and negotiate a hard rule. The reason I think it fell aside is because it was dominated by the larger firms. They wanted rules that would put their smaller firms at a competitive disadvantage. And this was going on at the same time when people began to be concerned about the effect on regulations on small firms, which resulted in regulatory flexibility. So it died. Negotiated rulemaking, you just don't see it anymore. And how would you, or how would anybody on the panel say, we're going to do this, we're going to make sure that the firms that don't have those resources, but are usually impacted by these things in a bad way, I would make sure that their voice is included.
Well, thank you, Richard, for the question, and it connects nicely to the previous question. I'd just say that a negotiated rulemaking process that we were trying was still a rulemaking and a formal one, right? And there was a rigidity to it, even though there was an attempt to make it negotiated and more collaborative. At the end of the day, it was just basically better dialogue among the regulator and regulatee. And, the great economist Alfred Kahn wrote about this extensively in his Economics of Regulation, his 2-volume masterwork. And then he went on to live this when he became the regulator at the Civil Aeronautics Board. And he thought this was such a chronic problem when he was running the Civil Aeronautics Board in the Carter administration that he convinced President Carter to abolish his agency. He talked about the incestuous relationship between the regulator and the regulatee and the so-called regulatory capture problem. And so he was trying to do something more negotiated and flexible at first, and then he says, the hell with it, I'm out of here, I'm done, and then hit the self-destruct button on his agency. That hasn't happened since, and it's not going to happen. We're not going to see any more serious comprehensive agency deregulation or abolition in this country because special interests won't allow it. And that's the end of that story, because they do buy into that process. Soft law at least opens up a new avenue to do something in a more creative, flexible fashion that maybe gets around that dynamic. Right? And doesn't have a formal, settled, one-size-fits-all, set it and forget it kind of approach. And that's the hope. It still has the element there of danger that there could be some players that exert more control. We did have at the federal level a multi-stakeholder effort, NTI-led, on some biometric and facial recognition issues, and privacy advocates walked out of the room. They just walked out of the effort to have a discussion about it, saying, we're not going to bargain on this front, leaving only certain industry players to help government come up with some best practices and guidelines. That's not optimal, but there was a process that was underway, and they were still negotiating and debating these things, and we'll see how they play out for Dan's field and others. But I would hope that in the soft law context, you have a better chance of making these processes and guidelines work in real time that evade the dynamic that you just identified in the previous question.
Hillary, you had a question?
Hi, yes, I just checked on the global inventory of AI ethical guidelines. There are 167 at the moment. So we're not short of soft law, we're short of soft law that actually works. And I'm looking, when the bar came out, I'm looking at Microsoft's website and it's all, we will only give you that technology you can trust and all of that. So I think part of this is it's not a good look for soft law. So how are we going to get soft law that actually works, which was Gary's project? And I think, it's really making the whole sort of
I think that it has to be not just industry specific, but technology specific. I am very skeptical of very broad-based soft law principles, just like I am very skeptical of broad-based hard law, right? To write a good statute, you have to identify a concrete problem that you're trying to fix. You can't just say safety, right? And so I think in that sense, soft law is exactly the same as hard law. So I am very skeptical of these sort of international bodies setting these, very broad AI standards, because I think they're highly unlikely to work. I think they have to be significantly more targeted towards specific problems and specific forms of AI.
Sorry, there was a question at the back, and then I'll get to you. Sorry, can you speak up a little bit? It's hard to hear. It's hard to hear you down here.
I couldn't hear all the question, but I think I heard something about maybe like sort of AI like rating approach, and I'm not sure. There's an effort there have been three excellent breakout sessions at this conference already about AI governance. And one I was on yesterday about algorithmic audits and AI impact assessments, and there was another one that involved AI nutritional labels or better transparency and labeling mechanisms. And so there's an interesting movement afoot to have sort of international coordination on taking all these different soft law frameworks, and there's actually more than 100. How many were in the ASU report, Gary? 600 and...
Yeah.
650 or something. It was a lot. And, the good news is 1,000 flowers are blooming. The bad news is 1,000 flowers are blooming. There's a lot of flowers, and they could be weeds that take over the garden. How do you coordinate these things? And so the effort that's afoot now by some academics and bodies is to create some sort of formalized self-certification or rating system or auditing system or nutritional labels. And I think it's great. There's a lot of experimentation in this field. The trouble is that we're not talking about concrete, easily defined binary metrics when we come to rating AI or making it more transparent. When you have a nutritional label, you can scientifically count like grams of fat, calories, things like that. When you have octane ratings on gasoline at a pump that are regulated, it's either 87, 89, or 91, or it's not. With AI bias and disinformation, these are very, very subjective, eye of the beholder values, right? And so the fundamental problem for AI governance is not just the sheer number of frameworks or systems, it's the subjectivity of the values at stake. This gets back to Tracy's excellent point about why you need to go deeper and focused on context-specific dangers or harms, where you might be able to make things like transparency or explainability for algorithmic systems work more effectively and scale that up at the international level. But it works a lot easier for some values than others, and for some, it's never going to work. We are never going to have a globally coordinated body or effort on what is AI disinformation. I mean, good luck getting China, Russia, and America to sign on to any accord in that. We can't even get those three countries to sign on to the Biological Weapons Convention, for God's sakes. We're not going to get them to sign on to an AI disinformation treaty or framework. So it's got to be more focused, decentralized, and pragmatic. I think it can work in some contexts better than others.
Yes.
So our conference is about sort of the explosion of technology and how does that fit with the institution of law and hard laws that are passed and that might not be a fit for what's actually happening in the technological realm. Is there any concern expressed or discussed regarding this mismatch of hard law that's instituted with the reality of the technology, and when hard laws are instituted and they don't fit, they can't fit, does anybody see that as a corrosive factor in the sanctity of law in general? Sort of like when mom says, I'm going to pull this car over unless you kids stop riding in the back seat, and then mom doesn't pull the car over, and it sort of erodes mom's authority in general.
You know, it's an interesting question, and the public safety sector talks about trust in the community a great deal. We literally don't have enough resources in this country to actually enforce laws that we have already adopted. And so we have increasingly become a bifurcation between passing laws and feeling good about passing laws or regulations and all sorts of things, and then dropping the ball on enforcement. And we basically, enforcement has now become in many regards more partisan and politicized decision. And so we feel good about creating some laws and makes us feel good, and politicians stump on all the process they've made. But then we have a different conversation when it comes to enforcement. I think that we have a similar challenge here, perhaps, is that we might feel good by passing a bunch of laws and all that kind of stuff, but then the enforcement actions or the actual, what precedes enforcement, which is the investigation part, it won't happen. I mean, let's just think about a regulatory environment where there's laws passed around certification, auditing, all kinds of things. Where's the talent pool going to come from that actually understands how to do that? They're not there now. We just don't have that talent pool. And when we identify that talent pool, we suck them up into the private sector as fast as we can get them. And so how is that pragmatically really going to work? I think it has to be on the other side. And so you're concerned about the delegitimization of hard law and how that occurs, I think is a significant argument of why we should not rely upon that path, because I think it can follow really some bad precedents.
I would just add 2 points to the pragmatism, is that even if an AI agency, like what was suggested, were to come to be, Congress has to fund said agency. And how much money would that take to actually efficiently, if it could even be efficient, do that? And at the same time, the Supreme Court, which I know was mentioned yesterday, has slowly chipped away at agency deference. And the major questions doctrine specifically says that things that are either novel or important to the economy are not up to agency decision-making. So clearly we're going a direction where agencies likely may lose power in this space. So
I would also say this is just a gut instinct level response to your question, but I think the thing that undermines faith in the government's ability to do this is all of the public hearings that they're having, right? I started off very skeptical about soft law, and then I watched Zuckerberg's Senate hearings, 5 years ago, and left thinking, I don't want any of these people touching AI because they have no idea how it works. They don't even know how Facebook makes money, right? And so I think the government is doing a really good job of convincing any intelligent viewer that it's not well positioned to be dealing with these issues in any meaningful way.
Well, and it actually gets worse than that. Hard to imagine, but, I completely agree with your observation. I'm familiar with a company in my group that had an investigation started by a regulatory agency, and simply the pace of the request for information, the review of the information, the response back, and then the recommendation was so far out of date. I mean, we're updating and releasing pretty much on a quarterly basis, and everybody I know in this industry is at least on a quarterly basis of upgrades into platforms. And so when you take a year and a half for a regulatory agency to ask a question, think about it, review it, and come back with more questions, and then with a recommendation, it's like, well, what does that have to do with anything I'm doing today? And the answer is nothing. And so, I mean, just let's kind of go into that pragmatic approach of a regulatory agency, and I think we're going to pass some laws. I think that it's going to be the feel-good opportunity, and then it will have zero impact other than stifling innovation and creating more power into the large corporations that have the defense attorneys to deal with that regulatory environment. I think it'd be a terrible, terrible approach.
Just in closing, I want to quote a line from my favorite tech policy scholar who wrote a wonderful piece on governance of emerging technologies as a wicked problem, and pointed out that there is no single optimal solution to such a problem, but rather only a mix of substandard solutions that must suffice. It is therefore important, he said, to consider a, quote, collection of second-best strategies that intersect, coexist, and in some ways compete. That scholar, of course, is Gary Marchant, who I want to, again, give great credit to, because we're all here talking about this because he really helped pioneer a field of study of emerging experimental governance for emerging technologies. And I encourage you all to reread that 2020 article that he wrote on emerging technologies as a wicked problem, because it's the best summation of, I think, all the concerns or issues that we're raising in this conference. So thank you, Gary.
All right.
If I could say something about your Zuckerberg hearing, the emblematic comment at that moment, as I was watching it, was one of the congressmen, senators, asked Mark Zuckerberg, well, I understand you don't charge for your service. And he said, that doesn't sound like a very good business model.
All right. Thank you, guys. My name has been Benjamin Faveri. It's been an absolute pleasure to moderate this panel and get familiarized with much of your work. And thank you to the Charles Koch Foundation for funding much of this, as well as 3 of our panelists' upcoming work. Thank you. Have a good rest of your day.
Sure.